November and that the funding ran out in April. And the plaintiff is asking to have the rent paid or for the defendant to move. Rent is expensive, $1,300 a month. And there are also some late fees attached. So we determined that the rent through July was $2,650, $169.92 in court costs for a total of $2,819.92. The defendant indicated she had sought other funding sources and was not successful. Mr. Bush, anything been paid on this?
Not to my knowledge, Your Honor. I believe that the balance is still due.
Ms. Curtis, what's your position?
I got an appointment with Criminal Action Agency August the 10th, but that'll probably be too late. I don't know. I've been looking for jobs. Nobody was willing to hire me. Nobody have called me back, email me. Like, I checked every resource to try and get help. I don't know.
I don't know either. It's a tough gig, but you can't afford to live here. You haven't paid rent in several months. August rent is about to be due tomorrow. It'll be another $1,300 behind. So the total will be over $4,000 of unpaid rent. And I don't know that any funding agency will give you that much.
I don't think so. I don't think so. I don't think it's no funding down here where everybody keeps sending me to other people and I keep warned, but I keep getting denied. So at this point, at this rate, like I'm just lost. Day before yesterday was the 5th year of my mom's passing, so like I'm not doing too well about that.
Yeah.
I don't know. My mental is not right. I don't know. I'm just a single mom trying, and I can't do nothing. Like I'm stuck. Like,
well, you're going to have to move. Is the answer to this, and it's hard to move when you don't have anywhere to move to and you don't have any money. But they're about to incur another month's rent through July. The rent is $2,650. As of August 1st, it will be another $1,300. This is expensive for someone that doesn't have any money.
it is, and Keystone set me up for this. This is crazy.
Well, they set them up and then they fund them for a few months and then the funding runs out and then they just
push you on out there.
Yes, I see it multiple times a year. There isn't enough money to go around is the simple truth of it. You have 10 days from today to vacate, which we're going to call that August 10th.
Yeah, that's when I got this appointment, but I'ma just cancel
Well,
it.
they can agree to work with you. You stay in contact with this Lamont, but I would be very surprised if Community Action Agency will give you $4,000.
Yeah,
but they
I
might.
highly doubt it. They couldn't
But
help
that
me
would
in
just
Riverside, so
All right.
that's why I was in this predicament in the first place, because nobody wanted to help. And then when I got put out, everybody was like, oh, this. Man, whatever.
Well, it's better than nothing. You got free rent for November, December, January, February, March, and April at $1,300 a month. That's a lot of money. But the money just ran out. I think the hope is that people would get on their feet after a certain amount of time and be able to pay the rent.
If I'm putting in application and nobody is calling me, what y'all want me to do? Go sit at their job with a gun, hire me, or I'm gonna blow you? Like, I don't know what y'all want me to do.
I understand.
I put in these applications, nobody called.
All right.
I even put one in downstairs up under me. Why they ain't call me back? They open every day.
But even so, $1,300 a month is a lot of rent for one person.
That's what you need to tell these landlords then.
Yes. All right, Ms. Curtis. You got 10 days to pay $2,008.19.92. You can share this with Community Action. Stay in contact with Ms. Lamont. But the bottom line is you owe rent, you don't have any money, and it's a tough situation. All right, thank you all. Mr. Bush, you did provide a judgment and I signed it.
Okay.
All right, Ms. Curtis, I wish you luck.
Will you note in the judgment that the rent is also due tomorrow?
Yeah, August rent. Well, it says that.
Okay.
The defendant may be liable for money damages if additional rent is owed, which is August. All right. I don't know. November, December, January, February, March, April, 6 times. Six times 1,300 is $7,800. Isn't like nobody did anything for her, but she's
Your Honor.
right. It's hard to find
Just so
another
you know,
job.
this rent included.
It included what?
So high. All the utilities, the gas,
I see.
electric, and water. That's why
Okay.
it's so high.
All right, well, they're not gonna pay it anymore, and I guess we'll just do the best we can. All right. You can wait a day, obviously, if Community Action is gonna give her some help, but I'd be surprised if they give her that much. All right, thank you.
Thank you, Your Honor.
All right. Next up, I said a couple of cases early. It's Memory Lane's Mobile Home Park versus Rebecca Randall. File number there is 261328. The manager, Chris Corpening, is here, and the owner, Richard Pizzoli, is here.
Good morning, Your Honor.
Good morning.
Morning, Your Honor.
The defendant is not. We adjourned this from last week to today. I got a photocopy of, it looks like she's paid in full. Photo of defendant's balance, 0. The defendant said she was going to pay. Ms. Corpening, has she paid?
Your Honor, she did make a payment yesterday. I'm sorry. She did make a payment yesterday. She paid a partial payment of what was due and August rent.
Well, it says first payment. I can't see this very well. It's a poor photocopy of a picture. And it says second payment, 0 balance.
Your Honor, we were
So-
told that there was a balance still owing of $212.10. That is what our record showed. $212.10.
All right. This is set for $850. She may think that she's paid in full. How much is that $212.10? Is it court costs, or we determined court costs were?
Her costs were $110 filing fee and $52.10 in service of process fees.
That's what we showed. All right, I'm going to show this as 162 of cost.
Thank you, Your Honor.
And then 212.10 minus 162 would give us, oh, that's not right. $50.10 in rent. Do you agree, Ms. Corpening, that that's the balance due?
Yes, Your Honor, I do.
All right. Of course, August rent is due tomorrow. Did you say she's paid August rent?
With the payment that she paid, Your Honor, I took what was due first, and then partial would be August rent.
All right. Well, August rent isn't due yet. So how much, did she pay enough? Did she pay more than $537?
Yes, she paid a total of $1,350.
All right. You can't assess August rent yet. I was allowing landlords to do it. I did it, the last case that we just did. The lady owes $1,300 a month. I would have included August rent. I'd done it for a long time, many years, many judges did. And especially when COVID money was available, I put the additional month on there. And then they could get funded for July and for August. Somebody appealed it, actually legal aid appealed it, even though they had accepted it for years. And Judge Stutzman made a ruling that I can't do that. So I can't assess August rent. So she's paid in full. Any arrearage she has is for August.
Okay.
So I'll find the defendant has paid in full.
Okay. Thank you very much, Your Honor.
All right, 0, 0. July paid in full. I'll show us dismissed. But she does owe for August. I think she's gonna pay it. All right. I would have done it this way at one time, but I'm not allowed to. I'm constrained by the circuit court ruling. All right, so shows none. The case is dismissed.
Okay.
Thank you, Your Honor.
All right.
Thank you very much, Your Honor. We
Thank you.
understand. Thank you.
All right.
Goodbye now.
Okay. All right, those are our two early cases. Ms. Ferguson is here on her 9 o'clock case. Mr. Barth is here.
Need these, be quiet.
Mr. Barth, which case are you here on?
Landlord tenant case?
Yeah, you're on Barth and Callaway?
Yes, sir. Yes, sir.
All right, that's set for 9:10.
Yeah, I'm early. Tired.
Early is good. Ms. Ferguson, I was gonna just have you come right in the courtroom, but they put you in the conference room. We have to let the clock tick a minute. Mr. Odom is not present. It is 9 o'clock. I'm going to call the matter of Janice Ferguson versus Eric Oda. File number is 261292. Eric Odom is in possession of a double wide trailer on River Heights Drive. Janice Ferguson wishes to terminate the tenancy. There is no lease here, Ms. Ferguson. How did he come to be here?
I don't understand your question.
Say that again?
I didn't understand your question.
Well, he does not have a lease, but he lives there. How long has he been there?
For 2 years, maybe 3. When my husband passed away, my daughter sort of forced me to move. Let's see, I've been where I'm at for a year. So he's been there a little over a year. I was selling the property to my nephew and they weren't paying. And so I evicted them, and then Eric wanted to buy it, and he was going to set up, he was making all the payments and everything, and then he just stopped paying.
Is he still there?
Yep.
Is anyone else there?
His stepkids, I think, live there. I'm not sure. When I go there, nobody will answer the door.
When was the last payment made?
About 6 months ago.
Yeah, I would have just had you come right in the courtroom. I'm sorry they put you in that little room.
Okay. This has been an interesting ordeal because I first was selling it to my nephew, and they stopped making payments, and so
Well, I remember an earlier case on this piece of property.
Eric did just fine to start with, and then he had marital problems, and he and his wife were back and forth, and anyway, so.
Well, he was personally served by Deputy Morse on July 17th, and he is not here. He's subject to being evicted. That's 10 days to move out because he's defaulted. Let's see if he's shown up in the waiting room. He has not. I find by default, the plaintiff has a right to recover possession of the property. 10 days from today is July 1st, August 1st. No money judgment is entered at this time. He has 10 days to move. If he does not move, you can come to the courthouse with $10, $15 and ask for a writ of eviction.
Okay. He has 10 days?
Yes.
Okay.
That would be August 10th. All right, if you go out to the counter, the clerk will give you a copy of this order. And if he doesn't pay, Sergeant Morse and the team will do an eviction and compel him to move. He has a right, if he'd shown up, he would have got at least a 10-day adjournment, but he didn't show up. And so he's subject to default. All right, Ms. Ferguson, I wish you luck. If he doesn't move, they're gonna have to force him to move, and that's what this whole process is about.
Yes.
All right, good luck. If you go to the counter, the clerk will get a copy of this order for you.
Thank you.
Good morning. Which case are you here on?
Lane Gales, eviction from Deer Creek,
All right, come on in and have a seat.
back here.
Yeah, anywhere.
I'm trying to get it. There's shit on there.
To find out.
Oh, where is she?
She has bad reception, so she can't Zoom. She wants you to call.
All right.
Oh, stop your line. Okay. Okay.
All right, Mr. Barth, we're about to start.
Okay.
Hello?
This is Judge Middleton calling. Are you Patty Calloway?
Yes, this is.
All right, well, this isn't the ideal way to do it, where the judge calls you on the phone, puts you on the speaker,
Yes, I apologize.
but we'll do the best we can. Mr. Barth is here. All right, this is file number 261310. It's entitled Matthew Barth versus Patty Calloway. Mr. Barth is here by Zoom. Patty Calloway is here by telephone. And he wants you to move.
I have already moved.
All right, well, actually, it's filed as a demand for non-payment of rent. Let me look at this, so I get this straight. All right, so you've already vacated the premises?
Yes, sir.
Is this the house with the bicycles in the yard?
I don't believe so.
All right, well, there's a house on Peeler Street that's got some decorated bicycles.
Right next door.
Okay.
Right next door. That's my neighbors.
All right, well, you both live at the same house. And Ms. Calloway, you indicated that you have vacated.
Yes, sir.
When did you leave?
A few days ago.
Do you have any objection if I enter an order that just says he may have immediate possession? Have you got all your property out?
Except for some blocks. So, but he do whatever.
There is no lease. Was there an agreement for a payment of rent?
No,
Is that the date you wanted on there?
August 10th.
I just didn't know. I didn't think. Okay.
Was there an agreement, Miss Calloway, that you were to pay rent?
Yeah, for when I could, but it wasn't on paper.
No. Where have you moved to?
I don't have the exact address yet.
What town is it in?
It's still Three Rivers.
All right. Mr. Barth, is that acceptable if I simply enter an order that says you may have immediate possession of the premises?
Yes, it's just fine.
All right, I find by consent, I'm not going to order any rent to be paid, but if you want to sue her for money damages, you can sue her in small claims court. No money judgment is entered at this time. I'll just go with the court costs as the fee, 55 and 41. Court costs are 96.44. Plaintiff may have immediate possession. Normally, when you vacate a tenancy, it's required that you turn in the keys and give the forwarding address within 4 days of your moving, but there is no lease here. I get the impression there was some sort of a relationship that's broken down. He wants you to move. I'm not sure what the circumstance was, but you vacated. You have to pay the money if you wish to stay there, and you've already moved. So the date is for July 31st. You have until August 10th to appeal this in that unlikely event. So Mr. Barth, you have possession of your premises back at 607 Peeler Street. I've not ordered any money damages. If you wish to sue her for money, you can do that in small claims court. But she's vacated the premises. You don't need a writ. My suggestion would be that you change the locks, but that's up to you. All right, so you're both good to go. Thank you. All right, Ms. Calloway, good luck.
Okay.
I've got more people in the waiting room. Let's see what we've got. Oh, I just. I'm actually removing. All right, good luck, Mr. Barth. All right, our next case starts in 7 minutes. We've got several Fleeman Bradshaw cases. Excuse me, I'm about to sneeze some more. I've been doing a lot of that lately. That's what you want to watch. Ms. Gales, your case is set for 9:35, but you're in the right place.
Okay, good.
But Mr. Fleeman is here, so we may be able to start early if there's a time for that.
Would you like me to move up?
No, you're fine right there. All right, we've got several cases from the Bradshaw Freeman firm, now known as the Casey Strong firm. And they usually go quite well. I do have, as I indicated, a criminal case. A lot of people got arrested last night. Ended the day at 97 people and started the morning at 103 people in custody. So somebody posted September Knowles bombed. My intention was to hold on to her until we could get some services, but she is entitled to a bond and she posted it. She has such a notorious history of not showing up when she's supposed to. We'll see what happens. Well, the sun is still shining. It's a privilege to have windows in here. For 45 years, I was in that other courtroom with no windows. Never knew what the weather was, but it's very pleasant when the sun's out. I don't know what it'll be like in the middle of winter when you're watching the blizzard through the window, but I guess I won't be here to experience that. All right, we do have people in the waiting room. So we've got Michael Rizzuto. Oh, he's the newest member of the Bradshaw firm. Good morning. Mr. Rizzuto, I guess they're going to get their money's worth out of you there. Now you got a landlord-tenant docket.
Yeah, I'm actually coming to you live from the Three Rivers facility. So we've got a lot going on here today.
Okay. Your firm also has a defendant who got picked up on a bench warrant. It's Casey's case. If Casey had shown up, I would have probably asked you guys to sit in on the arraignment. He failed to appear for a pre-exam conference on a felony methamphetamine charge, but I'm not gonna drop that on you in the middle of a landlord-tenant afternoon.
Like it's totally up to you, Your Honor. If that's something you want to handle, I'm more than capable if you want.
All right. Yes, all right. Maybe we'll deal with that here while we're. Hello, Deputy Keeley. Could I see James Anthony via Zoom? All right, thank you. Bye. All right, thank you, Mr. Rizzuto. Our first case is Three Rivers Limited versus Joshua Jackson. And somebody's here by telephone. Who's here by phone? 7458. Who am I speaking with?
This is Lee Love.
All right. I don't really like doing it by telephone, but sometimes that's what happens. Ms. Love is here on a Three Rivers Limited matter also. Also present here in the courtroom is Alana Gales on a Deer Creek case. And so I'm going to advise Ms. Love and Ms. Gales of their rights as tenants in a landlord-tenant proceeding. Ms. Love, your landlord is asking you to pay the rent or move. And Ms. Gales, I think yours is the same circumstance. Yes, talk about that in a minute. You're a defendant in a landlord-tenant case. In such a case, you have a right to hire a lawyer. If you can't afford a lawyer, you could see if legal aid would be willing to represent you. They usually are here with us. I believe they're unavailable this week. And no one is here, but you do have the contact number for legal aid, or you could seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first court appearance, or be prepared to file a written demand for a jury trial within 5 days, pay the jury demand fee using the state court administrator form. The judge can waive that fee if you have an inability to pay it. If your landlord has asked you to pay rent in a non-commercial setting, you may be eligible for some emergency financial assistance from the Department of Health and Human Services, Community Action Agency, Neighborhood Inc., or other funding agency. If that's the case, they may be able to assist you with some of the rent. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can refer the matter to mediation. That has never happened, but one day it might. And finally, if both parties can agree on a resolution, that we could file what's called a conditional order of dismissal, and the Bradshaw firm is preeminent in that. They, I think, actually helped create that form in Kalamazoo, which was later adopted by the whole state. All right, Mr. Michael Rizzuto is here from the Rizzuto Strong Law Firm. Mr. Rizzuto, what's the current arrearage? Oh, no, wait a minute. This is material noncompliance. Ms. Love, yeah, they want you to move out. They're alleging that you have violated the terms of your lease, and they want you to move. And if you are evicted, it makes it difficult for you to get back into other subsidized housing. The attachment to the notice to quit dated May 8th lists the reasons why they wish to terminate your tenancy. They list multiple non-compliance issues and other good cause. And they want you to move. The law requires that I adjourn this matter at least 7 days. Ms. Tyler is here from the complex. Ms. Love, what's your position? Ms. Love, can you hear me?
Yeah.
Ms. Love, they want you to move out for alleged violations of your lease. The law requires that I adjourn this matter at least 7 days for you to perhaps get some representation from legal aid. What's your position here? Ms. Love?
Yeah, can you hear me?
Yes, not very well, but.
Can you hear me now?
Yes.
Okay. The only thing that I know of was being late on rent, and that was the reason for the eviction.
Well, the notice that they gave you back in May they also indicate that you failed to recertify.
So the recertification I have made during the time from when I got that notice. I had an appointment the day of the tornado. I've made quite a few appointments to come in and do my recertification, and nobody was there. Our regular person that does the office was on medical leave. And we had somebody that was filling in for her, and I made several attempts to left work early to come in and for appointments with her, or with the person that was taking over for her while she was on medical leave.
All right, well, that may be something to explore further. The tornado was March 6th. It's now July 31st. And those are the.
Yeah, the recertification is done now. Me and her worked on it and got it done.
So the recertification is done?
Yes.
Ms. Tyler, you agree with that?
Yes, we have been actively getting that completed because, like she said, I was out on medical leave. And so there was some complications in the office during that time.
But you're still seeking to terminate the tenancy?
That is what I get from the corporate office, yes.
Ms. Love, I would suggest that you contact legal aid this afternoon and see if they would be willing to review your case. Otherwise, you may be compelled to move out. I'm going to continue this matter until Friday, August 7th at 1:40.
Okay. And you said August 7th at 1:40?
Correct.
Okay.
I want you to either come to the courthouse or be able to Zoom in. I don't want to do this just by telephone. But we will continue this matter for 7 days. I would strongly suggest that you contact legal aid and see if they can give you some legal assistance in this matter.
Okay, and just so you know, sir, the late on rent and stuff like that, I have been my rent is paid in full, and it has been paid since the tornado in full on time.
They accept June and July's rent?
Yes, I've been paying rent ever since I got the eviction notice.
Mr. Rizzuto, that may be an issue under Park Forest. Once they file a termination of tenancy and then accept rent, there may be an issue regarding that.
And I would also like to recommend that Ms. Love, if she's willing and able, to reach out to our office as well, and we may be able to not provide legal assistance, but obviously kind of point her in a proper direction moving forward.
All right. So we'll see where we go with this. Once they file a termination of tenancy, which they did on May 8th, they're not supposed to accept any rent. And if they accepted June and July's rent, it may affect their ability to go forward in this case. So I think you could use some legal assistance. All right, Ms. Love,
Okay.
You're good to go.
All right, thank you, sir.
Mr. Jackson, who's your landlord? That's our first case. You're late for your own hearing, but you are here. All right, let's see who else we've got. Mr. Anthony, I brought you in because someone is here from your lawyer's law firm. We're going to deal with your criminal case here in a minute, but we'll deal with that. Oops. Laura, now my camera is off. Gee whiz, it's always something. Let's see who else is here. User and Janice Goodwin. Jessica Goodwin.
Yes.
All right, Miss Goodwin, I can see you. Who is here as user?
This is Edgewater.
I wish you'd be able to get a name. Somebody needs to help you with that. You always come in as user. I wasn't. All of a sudden, my camera went off. Which case are you folks here on? All right. Okay, Ms. Richmond is here. We got a lot of folks here. Let me tell all of you that you are here on a landlord-tenant matter, except for Mr. Anthony. In a landlord-tenant matter, you have certain legal rights. You have the right to hire a lawyer. If you cannot afford an attorney, you can see if legal aid would represent you or seek other legal advice. All of a sudden, my camera just went.
I'm afraid it's
What's that?
I'm afraid it's not enough.
All right.
We might lose everybody.
All right, we'll just leave it for now. Anyway, it just went out. The problem is, no, it is a problem because I can't see anybody else. Darn it.
No, man.
I hate to have you shut me down. I mean, that's.
Yes. Well, I won't be able to see anyone.
Right. Well, let me back.
Yeah, it just went out.
Shut.
All right. Well, there it goes. All right, we'll hope for the best. Okay. Mr. Jackson and others, You also have a right to have your case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell the court at this first appearance or be prepared to file a written demand within 5 days of today and pay the $50 jury demand fee unless you have the inability to pay it. Court can waive it. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can help set that up. And finally, you may be able to reach what's called a conditional order of dismissal if both parties can agree on terms and conditions. If it is a non-payment of rent case, you may be able to get assistance from the Department of Health and Human Services, Community Action Agency, Neighborhood Inc., VA, or other funding source to try to assist with the rent. Mr. Rizzuto is here on behalf of the plaintiff, Three Rivers Limited. Their manager, Shana Tyler, is here. And Mr. Jerome Joshua Jackson is late, but he is here. Mr. Rizzuto, this is filed as a demand for non-payment of rent. What's the status here?
As of my notes of yesterday, we have an amount of $3,443.93 due and owed.
Through July?
Through July, correct.
How much are court costs?
Of that amount, $184.
All right, so I need to subtract 184. Give me the rent and then
the rent
cost.
is $3,259.93.
And the court costs are
$184.
So the total due is $2,443.93. Rent is $916 per month, and tomorrow another month's rent is going to be due. Mr. Jackson, could you unmute your microphone?
Yes, I agree.
What's your position here?
I'm trying to do what I can as a single man, a single father. I actually had the money a month ago to pay most of it, and it got stolen off my card. The day when I was getting ready to go pay it at Walmart, they went to swipe my card and it was not even on there. And then I come to find out somebody stole my money off my card, almost $1,100 something off my card. So that set me back, and ever since then I have been doing nothing but trying to work up to get this money back.
All right, well, the law requires that I adjourn this matter at least 7 days for you to either get some legal advice, or have you gone to Neighborhood Inc. or Community Action Agency or anyone?
Yes, sir. I called Neighborhood Inc. They told me that they couldn't help me because it was a subsidized. If it's subsidizing, they don't do subsidizing.
Yes, that's right.
After I get off of here, I am planning on I have to turn in, I got to turn in my pay stubs, and my 6 months worth worth of payments to DHS, so to see if they can probably help me. And I'm supposed to do that today after I get done with this.
All right. Well, I'm going to adjourn this to August 7th at 1:45.
Okay.
We'll address this further. My advice is always the same. Stay in contact with your manager.
And we're going to set this for sentencing. Is that accurately stated?
Yes, sir.
All right. Mr. Hall, how old are you?
41.
How far did you go in school?
I only made it to my junior year.
Are you able to read and write English?
Huh?
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, well, I take blood pressure medicine.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What we're going to do is do a level 2 pre-sentence investigation. And we're going to come back here in about 8 weeks for sentencing. I've told Mr. Fox, based upon what I know about this case and what I know about you, it seems like that I would put you into my community control program. In other words, this does not appear to me to be a prison case. Other than that, has anybody made any threats, representations, or promises to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the 3rd page, there is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Fox before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of discharge of a firearm on or near prohibited premises. This is a 2nd-degree felony. It's punishable by up to 8 to 12 years in prison and a $15,000 fine. There's no mandatory prison in the case. It does carry with it, though, a presumption that I would send you to prison. We also have a specification for the forfeiture of the firearm that was involved. We also have a inducing panic. That's a 4th-degree felony punishable by up to 18 months in prison. We have 2 counts of negligent assault. Each of those are 3rd-degree misdemeanors punishable by up to 60 days in jail. If I do have to send you to prison in the case, either initially or because you violate the terms of your community control, then you would be subject to a mandatory period of post-release control of anywhere from 18 months to 3 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at that trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View, has the state had the opportunity to consult with the victims in the case?
Yes, Your Honor. The victim's advocate, Ms. Kennard, and I have met with both of the victims in the case, consulted with them, and explained options and the plea offer in the case, and both of them are in agreement with the resolution of the case in this way.
And what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on March the 6th of 2026 in Hamilton Township, Warren County, state of Ohio, the defendant did discharge a firearm over a public roadway, causing physical harm to both of the victims. The defendant possessed a Rome Arm Mini Draco 7.62 by 39 millimeter semi-automatic pistol that was used as instrumentality in the commission of that offense. Further, that the defendant's conduct did cause the evacuation of a public place and public alarm. He was reckless in disregarding the outcome of his actions that resulted in an economic harm of greater than $7,500.
Any on those facts, Mr. Fox?
No, sir.
Mr. Hall, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
Do you understand the right you're giving up by entering a plea?
Yes, sir.
What's your plea?
Pleading guilty.
Based upon your plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. You need to go back down to pretrial, report to them. Tell them you're there to fill out the paperwork for the PSI. We'll see everybody back here in about 8 weeks. Anything else?
No, Your Honor.
Do we get a date there?
Because I don't reach out to you via email.
Very good.
Okay?
Thank you.
All right, that's all. We ready? All right, next is the case of the state of Ohio versus Brian Cheney. This is case number 25 CR 42760. Present before the court is Mr. Cheney, represented by Mr. Kidd, and we have Mr. Harrison, the prosecutor's office, and Officer Sukovecki from probation. We are here today for, it says final probation violation. Technically, I think we're here for a further preliminary probation violation because Mr. Cheney was going to hire a lawyer, but then he couldn't get one, so we set it on here. We appointed Mr. Kidd. We do need an affidavit of indigency for him to sign. I don't know that we have the paperwork all in order, but we're going to go forward today, right, Mr. Kidd?
We are, Your Honor.
All right. Mr. Mr. Kidd, does your client wish to have a contested hearing in this matter?
Your Honor, he does not. I am in receipt of the report of community control violation that was filed on July 9th, where he is alleged to have violated general condition number 13. The to wit says that he failed to follow the rules and regulations of the Warren County Jail. To that, he would admit.
All right. Mr. Cheney, do you understand the right you're giving up by admitting to this violation?
Yes, sir.
Is this what you want to do?
Yes, sir.
Do you admit or do you deny that you violated probation?
I admit.
Based upon your admission, I find you have violated the terms of community control. We have 193 days of jail time credits. Does that sound right to everybody?
Yes, Your Honor.
Yes, Your Honor.
Mr. Harris, anything additional from the state?
Your Honor, based on the allegations, we ask that this community control be terminated and they serve additional period of time.
Officer Sukovecki?
I have nothing further, Your Honor.
Mr. Kidd?
Your Honor, in regard to our conversations in chambers, we would ask that the court impose the additional local time with the credit that's commensurate, which I think is result like in another 77 days of jail.
Mr. Cheney, anything you want to tell me?
No, sir.
All right, the court is going to impose 270 days in the county jail. I'm going to credit you the 193 days that you have already done. Technically, you're on community control while you're in the jail. So if you get in a fight, get caught with drugs, I could still send you to prison for up to the maximum penalty. But finish out your days, you'll be neutrally terminated from supervision upon your release. I will make
I'm not at work right now. I have to work tonight.
All right, well, show up on time next week, and it'll be at 1:45. It'll be by Zoom once again like this. All right, you're good to go, sir.
Your Honor, can you clarify the numbers on that case real quickly with you?
3,259.93, 184 for a total of 2,443.93. Mr. Jackson, when we see you next month, there's going to be an additional $916 due for August.
Another 900. Why did it go up to 900?
Well, it shows your rent is $916 per month.
And see, that's what I was trying to explain to them, that I needed that to be lowered because I don't have that kind of money. I don't even make that a month. I don't have my Social Security anymore.
Well, I don't know the answer to that, but that's what the lease says, that if you can't afford to live there.
No. I can afford to live here. It was just that they were supposed to have lowered it back in April or March when when my rent went down, and then they didn't. It didn't get lowered down because we had no residential manager.
All right, so you're saying you were supposed to have a recertification?
Yes, sir.
Did you have one?
It didn't get done until I think it was late July. It was late July, maybe early June is when it got done. It didn't get done right away when my Social Security stopped.
All right. That may be an issue. Ms. Tyler, you have any input on that?
The research was done. It was started in May, and it will drop to 502 starting July 1st.
All right. Well, we'll address that next week.
Okay.
Hi, Mr. Jackson.
Thank you very much.
August 7th at 1:45.
Yes, ma'am.
All right. Next, Ms. Chitwood, and then Ms. Gales. Ms. Chitwood, can you hear me?
Yes.
All right, this is Bongwater, wait a minute. Edgewater versus Chitwood. This is another non-payment of rent case. Rent is alleged to be $667 per month. Let me see who else is here. We got Stephanie and Penny Moore coming in. Mr. Rizzuto, what's the arrearage here?
I have in rent $521.23. In court costs, $182.92. For a total of $704.15.
That's through July.
Correct.
Ms. Chitwood, what's your position?
And I went, okay, I was back to 923, which I paid that up. I went to pay my rent at Walmart and it had a red flag, which it still has a red flag. I couldn't pay my rent. And so I waited until the court date to find out what's going on, which I told Dan I might do the money order and send it into them, but I didn't do that. It's still on my card because I didn't know what I should do.
Well, I would recommend you go into the office and see Dan. And I'm going to adjourn this matter 1 week to next Friday, August 7th.
Because I can pay my rent.
Yeah, it sounds like you have the ability to pay it. You just need to get squared away. So now, August 1st, which is tomorrow, another month's rent will be due. And so you need to go, say that again?
I get paid on the 10th. See, I work at Walmart. I get paid every 2 weeks, and my rent is normally never on time before the 10th, before the late date. So it goes over. And I let Rhonda know that, and she said, just try to keep it up. But I get paid this week.
We're going to continue this to next Friday by Zoom like this at 1:50. Are you at work right now? Ms. Chitwood, I would advise you to go in and see the manager, make any payment, figure out what's due, and then additional rent will be due for August as of tomorrow, but your signal right now is frozen.
Yeah.
All right, you go in the office. If you've got money to pay it, any money you pay can be applied to your rent. And then we'll discuss it next Friday at 1:50 and see how you've done.
Okay.
All right, thank you.
Thanks.
All right, Mr. Rizzuto, we're still plugging away. Ms. Gales is here. Then we'll do Mr. Anthony, and then I'll let you get on with your morning. The next, Ms. Gales, would you come have a seat right here? Deer Creek versus Elena Gales. Except for 9:35, we're a few minutes behind. Wow, I got a bunch of people in the waiting room. Phone numbers. Anyway, are you Elena Gales?
Yes.
She's been here all morning watching the proceedings. She's heard me go through the rights. This is also a demand for non-payment of rent. Julie is here from Deer Creek. This is also a non-payment of rent case. And Mr. Rizzuto, what's the arrearage here?
Your Honor, in rent, I have $3,685.44. In utilities, I have $74.64. In court costs, I have $201.62 for a total of $3,961.70.
All right, Ms. Gales, they contend that through July, your rent is $3,688 behind. Now, tomorrow is August, so you're going to owe another $957. So you're almost $5,000 behind in your rent. Do you have a plan here?
Yes, my daughter just started a new home health aide position where she gets paid to take care of me, which increased her funds significantly. And we'll be able to get caught up within 3 months and ahead. She wrote out a statement for Deer Creek that she was gonna help me with my rent because I didn't have quite enough income to cover the rent. And then her position, employer changed. And there's a lot of red tape with state-funded employment. But within 3 months, we should be caught up and ahead.
As you heard me say, the law says I have to adjourn this matter at least 7 days.
Yes.
I'm going to adjourn this to August 7th at 2 o'clock.
Okay.
Now, there's problems. The law says you have to pay this rent or you're subject to being evicted.
Yes.
I'm going to adjourn this matter 7 days, and when we come back, it will be August, and you're going to owe another $957. So it'll be almost $5,000. You have 10 days to pay $5,000. So that amount would be due by August 17th. They don't have to give you 3 months to get caught up on your rent. They can if they wish to. They don't have to ask for the writ of eviction within 10 days. They have 56 days to ask for it and 56 more to serve it. But the law says you have to pay the rent within 10 days or you're subject to being evicted. And that 10 days is going to start on August 7th. So you need to go in and see management and see what their position is. Okay. You need to go in and see your manager. They can agree to work with you on some sort of plan to get caught up on your rent, but they don't have to. By the letter of the law, you have to pay the entire amount of the rent within 10 days or you're subject to being evicted. And if you get evicted, then you can't get in anywhere else.
Right.
So again, you could benefit from a consultation from legal aid, but at the very minimum, I would direct you to go in and see Julie at the office and see if they can agree on something that would allow you to have a period to get caught up on this.
Okay.
Mr. Rizzuto, you got anything to add?
I just would note that in our file, we have also received some lease violation notices. So just to add that to let Ms. Gales know something else she may want to address moving forward.
What kind of violation?
So I have one from 6/10 that notes failure to maintain unit in a clean and sanitary condition. And then I have one from July 22nd, which also mentions the failure to maintain unit in a clean and sanitary condition, as well as allowing unauthorized persons to live in the unit.
Is that your daughter?
My home health aide, and when we first moved in, they knew that she would be there. And he said, Marshall, the leasing manager said to add her at the end.
She's not on the lease.
No, he said to add her after I got moved in.
Well, she's not on it presently. There's apparently, there's a sanitary issues and there's a lot going on here. You could benefit from a contact with legal aid. according to them, she's living there off book. Your rent is calculated based on one tenant and one source of income.
Right.
If your daughter is in there and she's not on the lease, and then they put her on the lease and they add her income, it may change your monthly rent. So there's a lot going on here. So my advice is the same. I would recommend that you contact legal aid. They're not here today, but also that you talk to your manager. Right now, your daughter's not on the lease.
Right.
And she's not entitled to live there.
Well, we went to add her onto it like they told us to do, and they said we couldn't do it till March.
Well,
so they were aware she's there.
On the floor.
Well, it's not March. We had it March, April, May, June, July, and now August.
They said we can't add her to the following March.
Oh, till next March.
Right.
Well, that means she can't live there.
Right. Okay.
All right. Well, you're gonna have to address those issues.
Okay.
All right, Ms. Gales, I'll see you next Friday afternoon at 2:00. You're welcome to come here to the courthouse, just like you did here today.
Okay.
Thank you.
Thank you so much.
Next, our last case for the Bradshaw office is Sturgis Place Apartments versus Baum. I have received a notice of dismissal from Mr. Fleeman, dismissing that matter, and I will sign it. All right, Mr. Rizzuto, stick with me. You're doing criminal matters in Three Rivers, but a client of your firm is here, Mr. James Anthony. Mr. Anthony, can you hear me?
Yeah, can you hear me?
Yes. This is Judge Middleton. Michael Rizzuto is here. He is a partner to your attorney, Casey Strong, and he is also going to be handling matters here in St. Joe County. We're looking forward to that. There is a bench warrant for your arrest in this file, 260608FY, because you failed to appear for your pre-exam conference. And I waited 48 hours, and you didn't show up or contact your lawyer, so I issued a bench warrant for your arrest. Bond is set in the amount of $20,000. How did you come to get arrested last night?
I was just driving. I had a buddy's car, and I guess they didn't have a.
You got arrested where?
Kalamazoo.
They brought you down from Kalamazoo?
No, they made me sit there, and they made me sit until the next day when St. Joe came and got me.
All right. Do you have any charges in Kalamazoo?
Shouldn't.
Okay. Did you ever talk to your attorney, Casey Strong?
No, sir.
All right, well, that's not good. I'm going to reset this. I'm going to set a pre-exam conference. We need to get the case back on track. We don't accomplish much when you don't contact your lawyer and you don't show up for your court hearing. I'm going to set it for a pre-exam conference August 11th at 8:30 and a prelim if needed for August 18th, 2026 at 1 o'clock. I set the bond at $20,000. You never contacted your lawyer. You didn't show up for your court appearance, and you got arrested just on happenstance. Are you employed somewhere?
When I noticed that I had missed that court date and never everything was already passed and I kind of just went into hiding, to be honest with you.
All right, you just sort of went into hiding, you said?
Yeah. So,
all right, well, that's not a good way to deal with it.
So I kind of lost my job and everything.
All right, well, the good news is the case is back on track for August 11th. The bad news is I set your bond at $20,000 cash or surety. You can't just go into hiding. Eventually it'll come back, so we'll deal with it. It's not that terribly of a compelling of a case, but you can't just blow it off. So, Mr. Rizzuto, I do appreciate your help. We'll let Ms. Strong know that this matter will be on for pre-exam conference on August 11th. She can contact her client at the jail. You've also got $345 of other unpaid tickets, and we're not going to worry about those at this point, Mr. Anthony, but you're going to sit unless you post this bond. Going into hiding is not a solution to that problem. So, Mr. Rizzuto, you did a fine job here this morning. Thank you. And thank you for agreeing to help with this additional matter.
Your Honor.
All right, thank you. Mr. Anthony, you're good to go.
Thank you.
Mr. Rizzuto, you're good to go. All right, everybody stay right where you are. We got to kind of reload here. I'm going to take this criminal case out. I'll be back in about 2 minutes. We've got some discovery hearings at 10 o'clock, and we've got a number of landlord-tenant cases that we're backed up on. So don't go away. I'll stop the record. All right, we'll be right back. Here for Kelsey Craig. So Stephen Pirock is here for Kelsey Credit Union. Mr. Katz is here for all right, now we've got some other people waiting I need to identify. I've got 2 people here by telephone and 1 people by an odd name. So telephone ends in 7872. Who am I speaking with?
7892, is that the number?
Yes.
That's Pamela Jones.
Pamela, what's your last name?
Jones. Jones.
All right, then I've got somebody who ends in 3310. Who is that?
3301, that is William Ray, REA.
Now I had somebody else. I've also got Stephanie with her microphone and camera turned off. Who is Stephanie?
Stephanie Walgast.
All right, Ms. Walgast, can you turn your camera on?
Yeah.
All right, Mr. Pirak, you're here on the Walgast matter.
That is correct, Your Honor.
Ms. Walgast, could you turn on your camera, please? All right, very good. This is file number 252571GC. It's entitled Kelsey Credit Union versus Stephanie Griffith Walgast and William Walgast as a co-signer. Mr. Stephen Purak is here for Kelsey Credit Union. This is a discovery subpoena to inquire as to your ability to pay on this debt. William Walgast was also subpoenaed for this date. Where is he?
He is at work as I don't start work back up till August, and he couldn't get the time off.
Well, this is a subpoena. It's a court order to appear. Mr. Purak, are you going to be satisfied with simply inquiring of this witness?
Your Honor, I'm hopeful that we might be able to arrange maybe a phone call or sometime when Mr. Walgast isn't at work, and I might be able to conduct an examination that way. I would have expected him to appear, but I'm assuming that they might be willing to accommodate me given what the court is alluding to here.
Well, I don't like the fact they didn't show up pursuant to a court-ordered subpoena, but I'll let you talk with Stephanie in a breakout room, and then we'll see where we go from here. Ms. Walgast, do you go by Walgast or Griffith?
Walgast.
All right, will you please raise your right hand? You swear or affirm any testimony you're about to give in this matter for discovery will be true to the best of your knowledge and belief?
Yes.
All right, I'm going to put you in what's called a breakout room.
Your Honor, sorry, I apologize for interrupting, Your Honor, but before you do that, I also believe we are here on a show cause because they failed to surrender the collateral as well.
Well, then I need William. What is the collateral?
It is a 2018 Ford Explorer.
All right, Ms. Walgast, you're under oath. We're going to discuss those issues. Order to show cause for contempt means I could either order it or I could incarcerate you until the order is complied with. You'll address that when you guys talk. So let me open the breakout room and when the button says join, Ms. Walgast, you join it.
Okay.
But they want this collateral back and Stephanie and Mr. Purak. All right, you both join and we'll see where we go.
Thank you, Your Honor.
Mr. Katz.
Yes, Your Honor.
Good morning.
Good morning,
It does
sir.
not appear that Randy Tepfer is here. Let me make sure he's not in jail. He was here Tuesday. He's not in our jail. He has a criminal case pending. He is not here for this discovery hearing. Would you call the hall for Randy Tepfer? He was here on 7/28 for a felony criminal matter.
Mike working today? It's like, I don't know, I guess that's Tuesday. You know.
He's set to be here on Tuesday, August 3rd. And he's also set to be here Thursday, August 6th. Tuesday, August 3rd would be at 8:30. And that is in file number 261168FY. He's also set to be here for Thursday, August 6th, in front of Judge Pattison. I won't be here August 6th. I'll be at the judge conference. I won't be here Tuesday. I'll be at the judge conference. I'll be here Monday. Mr. Katz, my inclination is to set this matter for an order to show cause for defendant's failure to appear for Monday, August 3rd at 9 a.m.
Thank you, Your Honor. That would be agreeable.
Does that work for you? You can zoom in. He's supposed to be here on a criminal matter in front of Judge Pattison. I will be here and I'll have time to co-opt him and set up this discovery hearing. If he doesn't show up, we'll issue a bench warrant and a criminal bench warrant. That'll be with file 261168FY. So can you or someone from your firm be available Monday, August 3rd at 9 a.m.?
Yes, Your Honor.
All right, we'll take another shot at it then. That's a solution to this in the short term. All right, thank you.
Thank you, Your Honor. Have a great weekend, sir.
All right, we're working on it. All right, that takes care of one of our two 10 o'clock general civil cases. We have a number of landlord-tenant matters left. So let's talk about who's left. Terry and Larry Richmond versus occupants. That's file 261373.
Your Honor?
And yes?
That's not me. It's Larry's brother.
Oh, it's Terry, T-E-R-R-Y.
Yeah.
Well, I knew this, I thought you guys had taken that property over.
We did.
So, all right, but it's Terry with a Y.
Right.
I'm familiar with this property. All right, we'll come back to it. So Larry Richmond is here on behalf of all unoccupied occupants at Parkville Road. So Mr. Richmond, just have a seat. Then we've got Richmond versus Jessica Goodwin, and Jessica Goodwin is here.
Mm-hmm.
We got Richmond versus Aaron Collins, and Aaron Collins is here. We got Phyllis Bell versus Frank Ray. Mr. Tim George is here on that case. The Bells are here, and Mr. Ray is here. Mr. Ray didn't show up last time we were here, but the matter was set for today at 9:50. So let's start with that one. And it's Ray, R-E-A. Mr. and Mrs. Bell, would you come have a seat right here?
This is John. I'm
okay.
John.
All right, you're not that party?
Yes, I am with that.
Penny Moore.
Penny Moore, Roosevelt. All right. All right, that's a different case. All right, Mr. George.
Yes, sir.
Your case was set for 10:50. The defendant is not here. What? Yes.
He had dashed away, yes.
All right, well.
I'm Denise.
All right, why don't you come up and have a seat? We've also got William Ray.
That's the brother, yes.
I'm also here for the Ray case.
Michael Henninger, it's other nephew.
So William is Frank's brother?
Yes.
Correct.
And what's your name?
Michelle Beidelman.
Hi, Mickey.
Oh, well.
You can. All right, Mr. Tim George is here. We were here on June 1st. He indicated at that time that the buyer was deceased with no spouse or children. They did find his brother, which apparently is William. There was no probate estate opened. More than 50% of the purchase price has been paid on this land contract. The property is empty. We continued the matter to July 6th, and then we continued the matter again to today. Mr. George, what's the status here?
Thank you, Your Honor. And just to hopefully clear up some of the confusion, as the court said, Mr. Frank Ray is deceased. We had moved to do the forfeiture notice back in March and then filed this complaint. At the time, we were only aware of Mr. William Ray, but then we did some more due diligence, and per his Frank Ray's obituary, we were able to find other siblings. So we served them courtesy copies of the pleadings in this file. That's probably why you see multiple people in here. And then if there were any other siblings that were either predeceased or had deceased since then, we did our best to try to serve any of their heirs. So as we've filed this case, we're trying to, because of the lack of a probate estate, make sure that we address everybody. For the purposes of today's hearing, there hasn't been any change in the financial nature of the case. We would ask the court to enter the judgment subject to, because of the amount that has been paid, the 180-day redemption period.
The family is going to have 180 days to redeem this. It's a land contract. It's not a lease. And everybody's going to have to get their ducks in a row. It's a nebulous situation when someone dies without a will and there's no estate opened up as to who has the right to do what. What is the current amount of the arrearage?
The total, as pled in the complaint, Your Honor, is $15,996.99.
Do we have court costs?
We do, Your Honor. We have service fees in the amount of $125.95. And then a filing fee of $215.
All right, 125 plus 215 plus 95 cents plus statutory attorney fee of $75. So the court costs are $415.95 plus $1,596.99. And I got my number wrong. Give me that number again, Tim. 515-996.
Correct.
Plus court costs of $415.95 is total of $16,412.94.
That's what I have, Your Honor.
Hearing on some and default on others. Because more than 50% of the contract price has been paid, the contract can be redeemed within 180 days. So the family has 6 months to get with the sellers, Ms. Bell, and see if they can work something out. If they can't, the property can be returned to the original seller and any equity would be lost. Mr. William Ray or Ms. Michelle Beidelman, does the family intend to redeem this property?
I just recently found out that all this was going on. I don't know what everybody else plans on doing. I haven't been able to talk to anybody yet.
From everybody on, this is William Ray. To my understanding, no, nobody is planning on taking it over.
All right. Well, it remains in limbo then for 180 days. Mr. George is available at his law firm. The number's on the pleadings if anybody wishes to discuss this with him.
He does not return phone calls.
Yeah, he never does. Their lawyer never returns phone calls.
Nope.
Well, try again if you wish to speak to him.
Yep.
All right, Mr. Ray. Thank you for being here.
Thank you, Your Honor.
All right, Ms. Beidelman, do you have any questions?
No.
All right, you're free to go. Yes?
I'm one of the sisters, but I'm not real sisters, but I'm into this lawsuit or whatever. She's involved in this too. Right. Because we had already made an offer on the property. So we had everything set for closing.
Well, wait a minute. I let Mr. George go. No. Laura, would you call Tim and ask him to rejoin me? Well, come up here and have a seat. Ms. Beidelman, would you trade seats?
Yeah, don't leave.
All right. Who are you and how are you connected?
Donna Horvath Miller.
Say that again?
Donna Horvath Miller. I'm Frank Ray's friend, but we were more like brothers and sisters, so we always went with that, okay? I took care of him while he was dying. And no, I did not know he was dying.
All right, well, you don't have any standing here.
No, but Frank, I was paying some of his bills and stuff, you know what I mean? And so that's about it, okay? But I'm not staking anything in the claim. I don't want the house, okay?
All right.
You don't have to say that right yet.
Whatever, shut up while you're ahead, while I'm ahead.
Hi, Tim.
All right. All right. So what do you want me to know?
Nothing.
Oh, all right.
I don't know why I was named in this suit. It's right there. I don't know.
I don't know either. They gave you notice, but if you don't plan on redeeming the property, you don't need to do anything.
Okay.
They tried to give as many people notice as they could, just to make sure they covered all the bases.
Okay.
All right. then you don't need to do anything if you don't want to try to
And
redeem
then,
this property.
excuse me, I have one question. So that you said they have 180 days to redeem the property.
Yes.
Is that from the date of his death or is that from now or when?
It's 180 days from now.
From now?
Yes.
Okay.
Okay.
All right, thank you.
All
Am I
right.
free to go, Your Honor?
Yes.
Thank you. Have a great weekend.
Thank you. All right, now let's see everybody else that we've got. I'm going to do Richmond and occupants and clear that one up, and then we'll see what's what. Mr. Richmond, would you join me?
Sean's gonna try to get you back.
He's here.
We lost you.
Tim, I apologize.
No worries.
There were two people that were here, Ms. Orbach, who was a friend of Mr. Ray's, who also got notice of the hearing. They don't intend to redeem the property. And so I just advised them they were good to go.
Okay.
They came up at the end. I didn't know we had another party here.
And I apologize that I was just contacting my client and she told me that you were letting me back on, so I logged back in.
All right, thank you.
Thank you, Your Honor. Have a good weekend.
Okay, we're working on it. All right, this is Terry, T-E-R-R-Y, and Larry, L-A-R-R-Y, Richmond versus all unauthorized occupants at 51510 Parkville Road. I'm familiar with this property. We've had cases on it before with Mr. Terry Richmond. Larry Richmond, are you now one of the owners of this property?
Yes, sad to say.
Who's in it?
There's nobody. They've been gone for 3 weeks, but I figured as long as it's gone this far, we'll just go ahead and do it. But just get so it's all done legally. But they've been tickling it. They've been gone for 3 weeks.
Well, I need to adjourn this because whoever was there was served by attachment. So I'm going to continue this to next Friday, August 7th at 2:15.
Okay.
I agree. They come back and squat again in there or something. Do you know who the people are that were?
No idea. No idea. And the lady that deeded that property back to us, she just knew her by the first name and she didn't know who they were neither. They moved in under her watch back in November.
All right. Well, we'll dot the i's across the t's. We'll address this next Friday at 2:15. Thank you. Do you even have a first name?
I can't remember. That was 2 months ago. Are you building your retirement home in Chet's place?
No, you're fine. We'll address this next Friday at 2:15. Thank you.
Okay. Thank you. Have a good weekend.
Well, everybody's telling me to have a good weekend, so I guess I better. All right. So we've got a number of defendants here. Aaron Collin is here and Jessica Goodwin is here. Long is set for 11:15, so we're not there yet. So Collins, we were here previously. So let's address that one, and then we'll address Ms. Goodwin. This is file 261340, Terry and Larry Richmond versus Aaron S. Collins. Ms. Collins is here, Mick Bauer is here from Legal Aid, and Terry Richmond is here. This was a demand for non-payment of rent. We had some calculations, and I'm not sure everything was completely clear. I thought we were at 196974, and August would be due. Ms. Richmond, what's the status here today?
It's the same as it was last week.
$1,817.05 in rent, $152.69 in court costs through July, with a total of $1,969.74.
Ms. Collins, you indicated you contacted DHS and Neighborhood Inc. How did you do? Your mic is on mute.
Sorry. DHS was waiting for 3 months behind, and so I was going to file that paperwork today after work because I'm still currently at work. Neighborhood Inc. said I was ineligible.
Well, on Monday, on tomorrow, another month is going to be behind. So I'm going to go ahead and do this. I'm going to include August in it. Then you'll be 3 months behind. Then DHS can assess. 1817 plus August of 745 gives us
$2567.05.
$2562 in rent and $152.69, or is that 182? I can't read my writing.
$152.69 in court costs.
All right. $2,714.69 through August. You told us about that rule last week, Ms. Collins, and it took me a little bit by surprise, but I've added the third month specifically to make you eligible for assistance. Theoretically, I'm not supposed to do that. I declined to do it once earlier, but there's no reason why the defendant would appeal this. Through August.
Okay.
The rent is $2,562 plus $152.69 in costs. It's a total of $2,714.69. That's due within 10 days from today, which is August 10th. No money judgment is entered. You have until August 10th to appeal this. I would encourage you to share this immediately with DHS. Ms. Richmond knows this. She does not have to evict you on August 10th. She has 56 days from today to ask for the writ. I don't have the back page of the judgment.
Oh dear. Do you want me to get it to you?
No, I got it.
Okay.
I'll just use this other one. I wrecked one last week. All right, Ms. Collins.
Yes.
I've made a finding that through August, you owe $2,562 in rent, $152.69 in court costs for a total of $2,714.69. If you pay that, you get to stay there and your rent would be due again on September 1st. If you don't pay it, you are subject to eviction on or after August 10th.
Okay.
Now, Ms. Richmond doesn't have to evict you on August 10th. Sometimes the DHS doesn't move very fast. And let's say they give you a partial payment of this, but not all of it. The only thing that cures this is paying the entire amount. A partial payment will not prevent the writ of eviction. If you do move, you need to turn in your keys and give your forwarding address to your landlord in writing within 4 days of your moving. All right, stay in contact with Miss Richmond, stay in contact with DHS. Hopefully you can get some assistance and stay there.
Yes.
All right. Any questions?
No.
All right, you're good to go.
Thank you.
All right. Next, we have Jessica Goodwin. This is also a continued case. This is Richmond versus Goodwin. We were here on July 21st, which was 10 days ago. The matter was continued to now. At that time, the arrearage, I think, was $530. Ms. Richmond, what's the status here?
It's the same through August. It's $520 in Brent. Court costs were $133.89 with a total of $653.89. Unless you want to add August.
I don't really want to. I did as an extenuating
Your Honor.
circumstance. Yes.
I do have my check for the August rent. As I said last time, I just got back to work from having surgery. I did pick up a couple of hours this week here so I can make extra money so I can get that other paid off.
Very good. Now, tomorrow, August rent is going to be due, but.
Yes, I have a check for $900 now.
All right. Very good. Sounds like you're going to work this out.
I'm trying. I said I had that surgery and was off work for 6 weeks.
Yes, and nobody decides, hey, I think I'll get sick and miss a bunch of work.
I was told on Wednesday that I was having surgery that following Monday, so it wasn't planned.
All right. Through July, rent is $520. Costs are $133.89. A total of $653.89.
And that's where I'm trying to pick up a couple extra hours so I can get that caught up.
All right, that's due by August 10th. Now, again, Ms. Richmond can agree to work with you for up to 56 days to get caught up on this. Partial payment will not prevent the writ of eviction, and on August 1st, August month is due. So let's say you give her $900 for August. She'll apply that first to July's rent and court costs, and then what will be left will be what's unpaid for August. But I think that you are working on getting straight with this. You got a good relationship with your landlord. All right, do you have any questions?
No, long as I can get out of here and get my daughter back home.
All right, well, you're good to go. Yeah, I appreciate your patience.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. All right, we have Village Manor versus Long, which is set for, we have McDaniel versus Suter, which is set for 11. Village Manor versus Long, set for 11:15. And then I have, the parties are still in that breakout room in that Kelsey Credit Union versus Walgas. So Meg, our next case isn't up for 20 minutes. I did direct a couple people in your direction that I thought could use some help. And we'll see whether they do that.
Yeah, we've gotten one, and I'm sorry that I had another hearing in Van Buren County.
I'm assuming you did. I didn't know if this was the weekend you had a wedding or what was going on, but I knew that you didn't just blow it off. You had something going on.
Appreciate that.
All right, let's return to Kelsey Credit Union versus Stephanie Walgast. kind of cleared the decks a little bit. We had a big backup, but we're back.
I was going to say, Your Honor, it looks like you moved through all that pretty darn efficiently.
I do the best I can. In the meantime, you guys have been discussing this matter in private.
Yes.
Mr. Paruk, what's the status here?
Yep. So Ms. Walgast tells me that she will voluntarily surrender the vehicle. I think at this point it makes sense to adjourn the show cause hearing for say 7 days to check for compliance. And if we get the vehicle back within that time frame, we can call the court, let you know, and get that off the books. She has complied with the debtor's exam component of this and answered my questions to my satisfaction. We have scheduled a time this afternoon for Mr. Walgast to call me and speak to me where I can ask him those the same questions as well. So I think we have a good plan of action here, Your Honor, if the court agrees.
All right. Ms. Walgast, did you hear everything that Mr. Paruk said?
I'm sorry, what was that?
Did you hear what the lawyer said?
Yes, I did. Yes.
And did you agree with your discussion that you had with him? You're going to relinquish the vehicle. I'm going to continue this matter for 7 days. If the vehicle is returned, that can be dismissed. He's going to engage in a discovery with your father by telephone later today. And that may rectify things. Are you employed?
Yes.
Where's that?
I work for Three Rivers Community Schools.
That's what I thought.
Mm-hmm.
Okay, let's adjourn this, or adjourn this show cause to Friday, August 7th, 2026 at 1:50.
Do we have to be present for that?
No, if the vehicle is returned, you don't need to be there.
Okay.
If it isn't returned, there will be a show cause to find out why it was not.
Okay. Okay.
And, but if it is returned, no one needs to appear.
Okay.
Mr. Paruk, anything further?
That is it, Your Honor. Thank you very much.
Is it Pure Rock?
Yeah, pure rock, like a radio station, Your Honor. Pure rock.
Pure Rock. Okay, got it. All right, we're good. You relinquish the vehicle, set up some sort of payment plan. Your dad may also be on the hook for this. And I expect I won't have a hearing because I think you're going to turn the vehicle back in.
Yes, sir.
All right, thank you.
Thank you, Your Honor.
Laura, I think this would be a good time to shut everything off and turn it back on, see if we can get the thing back up. So I'm going to shut this off. Ms. Suter, I'll be with you in a couple of moments. I'm going to turn this off and turn it back on. So I'd ask you to log in again in a couple of minutes, okay?
Okay.
All right, thank you.
Judge,
Same for you, Meg.
Okay, you're shutting down Zoom.
Yes, it got locked up somehow. All right, we're back. We've got a few minutes before we start up again at 11. I just shut it down to reconfigure it, and I think we're back up and running. We have had a busy morning. I had a criminal matter to do this afternoon, but I crammed it into this morning. And so we're in good shape. We're on the home stretch. And if it stays sunny and warm, I might leave at 3 o'clock today. So let's have a nice summer afternoon. You are the key to my peace of mind. Also, depending on which version you like, the Carole King version is also great. She wrote it. She ought to get credit for it. But either way, it's a great song. And I'm going to go ahead and shut this off. I've got somebody in the waiting room. Thank you all for watching this busy morning. People are struggling to pay their rent. I don't know the answer. They get $8,000 worth of help and that isn't enough. And then they're mad that they don't get more. And I don't know the answer to this question. All I know, and our rents are relatively lower compared to the rest of the real world, but people are having trouble paying $1,000 rent here in St. Joseph County on a $15 an hour job. It's a harsh reality. And they get sick and they lose a job and life comes on them. And then this mean guy in a black robe tells them they have to pay the rent or move. Nothing really fun about this. Guess I'll just lock it on me. There's no other people here in the courtroom. Ms. Suter, thank you for logging back in. We got our problem rectified. This hearing is set for 5 minutes from now, so just, you're not moving, are you?
No, I'm actually at work in my car outside.
Okay, it's a nice morning. I'll be with you in just a minute. Maybe we can start. The jail. I don't need anybody from the jail. Oh. Hi, is Judge Patterson doing polycoms at 11? Well, the jail just logged into my courtroom and I don't need them either. So I'm gonna, which case are you here on?
It's Collins.
On which case?
Gabriel Collins. Might have been the wrong ID here.
Okay, all right, thanks.
Yep.
All right. He's not my customer. July is too short. The whole year should be like July, even the hottest part. We had a wonderful July except for the wildfire smoke. We got a little bit of rain. Weather was sunny and warm every day. Long early mornings and long late nights. In my mind, July is the best month of the year. We need more of it. You only get so many Julys. All right, it is 11 o'clock. It is 11 a.m. It's the time for this matter, which is entitled Dawn McDaniel versus Ashley Suter. This was a termination of tenancy case, and I had some difficulty and some questions about it. From back in February, the defendant eventually vacated this property located at 62252 Schaefer Road. In the meantime, Dawn McDaniel has filed a complaint for money damages, asking for $14,000.
And she put the rent on there too, because on the paperwork that I got, she put whatever she put for rent back in February when we had court on there too. And the damages on the house were already there, and I have the proof.
All right, well, just a minute. The main problem is she doesn't own the house. This isn't her house.
She was put on the deed in the process of trying to evict me.
No, she wasn't. She's not on the deed as of today's check of the court records.
Oh.
And she's not here.
Judge Middleton, this lady is bonkers. Oh my God. I am missing work because
Well,
of
just a
her.
minute, just a minute.
Oh, my Lord.
Looking for a Dawn McDaniel. All right, thank you. Bye. According to the court records, this property belongs to,
Ryan McDaniel.
no, it belongs to Dwayne Suter. 6'2".
My dad shouldn't own the 62252. He is on the house for the 62930 Priest Road.
Yes, that's the house, but this is 62252 Schaefer Road.
Yes.
All right. All right, we got your house rather than her house. So we did all this checking and we checked the wrong address. And that's on me. So the eviction was from 62252 Schaefer Road. And we checked the title of, this is on me, I think I gave her the wrong information, or we didn't look at it carefully. 62930 Freese Road, which is where you live, but it's not the property from which you were evicted.
No.
That is 62252 Schaefer Road, so maybe she is on that one. We didn't look it up.
I know she was put on it in the process between December to February when we had court last time and everything was dismissed with the back rent.
Well, she isn't here for her own lawsuit.
I'm not surprised by any means.
No, I had the clerk do a title search on the wrong property.
So is she allowed to put the back rent back on there even though we had court for it and it was dismissed?
Potentially, yes. I didn't do a money judgment at that time. There was no lease, so it wasn't clear what rent was. When I made my original note, I put Ryan McDaniel was owner of the house.
Yeah, because the agreement was between him and I, not her and I by any means.
Yes.
I have the proof that she wanted no part of it.
All right, let's see what we got. She is on the lease as the owner.
Yeah.
Thank you. What we're doing now is just letting the clock tick.
Yeah, I'm tired of missing work because of this lady over nothing. Ugh.
Well, nothing. She's suing you for $14,000.
Oh, she ain't gonna get her way because I will take this to trial because I have all the proof of all the damages that her son did to that house. The only
Well,
damage
there
that was
isn't
done.
there isn't anything in her claim except rent.
Yeah, well, back in when we had court last
All right,
time, she
just stop. She claims that you owe 45 weeks of unpaid rent at $350 per week. Which would be $1,516 per month.
Yeah, I was paying $1,400 a month. Ryan and I agreed on that. And then when there was damages to the house that needed to be
All right,
fixed.
just hold up. She's not here, so I'm about to dismiss it.
Okay.
I got everybody I need for my next case. I don't have a plaintiff. One question, Ms. Suter, would be at what point Dawn became one of the owners of the property?
When it all started when I went to go speak to Ryan about lowering my rent, or if he would take like so much of what I was giving him each week to be able to fix the house because the basement was leaking. There's black mold in the laundry room. And he agreed with me that I can pay the $200, take whatever, whatever was extra to fix the house, to keep the receipts, which I had to put money into the house because the heater even went out. So I had to fix that. And he said, just keep the receipts and he would reimburse me. He was like, try and go the cheapest way that you can. And when Dawn got the whiff of it, that's when it all went down and she started to push for the issues. I had to get her for trespassing over there because she kept harassing me and it had nothing to do with her. And Officer Britton was the one who did it. Like, this lady's been nothing but problems.
All right, well, as soon as Mr. Butchart shows up, we can take up the Village Manor case, but this case isn't going anywhere because the plaintiff failed to appear.
Ooh, go away.
Ms. Suter, we're just letting the clock tick, and in a minute or two, I'm going to dismiss the case.
Okay.
This case was in February. When did you actually vacate the property?
You gave me 7 days, I believe, after that. We were out before March.
I think that needed to happen. We needed to get out of this.
Oh, Judge Middleton, I was on it like no tomorrow because I was over it. Like, she kept showing up next door, watching everybody move everything out. And I guess she was trying to go over there and start asking people if we were almost done.
I'm just going to show this matter is dismissed.
Okay.
Plaintiff fails to appear. No money damages. Costs are zero, damages are zero, no claim. Case is dismissed. Ms. Suter, you're free to go.
Thank you. Have a good day.
Thank you. I'm working on it. All right, that leaves us with one matter, Village Manor versus Long. Ms. Cousineau is here, Ms. Long is here, Ms. Bauer is here. We're waiting for plaintiff's counsel. The morning has been like this, fits of furious activity followed by the doldrums in between. This is the last matter we have set for this morning. It's entitled Village Manor versus Jessica Long. The file number is 261258LT. Here's Mr. Gromer. I would note once again, all the parties are present. James Gromer is here on behalf of Village Manor. Good morning.
Morning, Judge.
This matter was originally scheduled for July 10th. We had a hearing. This is a termination of tenancy case for, among other things, unlawful occupant of the premises. Defendant contends that she's a single mother of 6 children and that the unoccupied occupant doesn't really live there. The matter was continued until July 21st, and it was continued to further hearing. The unauthorized occupant is alleged to be Vladimir Cofield. I provided the court, the parties with information that there were 2 cases registered with the court where Mr. Cofield was listed as a resident at that address, 25207 GC. He was personally served at that address, 26416 GC. Again, listed that as his address, and he was personally served at that address, 1111 Laura Court. So we had quite a bit of discussion in the matter. The court also issued an escrow order. The defendant was to pay July's rent of $99. And I don't see that that's been paid. So we set this sort of as a status conference to see where we are and how much time we need to block out if we do need to have a trial. Mr. Gromer, I'll defer to you first. What's our status here today?
Your Honor, I have not had a chance to speak to Ms. Bauer today, and I'd like that opportunity if I could.
All right.
Before I address the court, if the court is so willing to allow me a few minutes.
Yes, I blocked out 45 minutes for this. If we need more, we can go till dark, but I'll put you guys in a breakout room and I'll sit here and think deep thoughts.
I'll just say, Judge, that if we stay till dark, it's going to go contrary to all of those people that wished you to have a good day and weekend.
Yeah, everybody told me to have a good weekend. It wouldn't start out very good if I'm here till 9:30 tonight. All right. So you'll be efficient with your discussion. All right. In the meantime, Ms. Long, I'm going to put you in the waiting room, and Ms. Kuzma, I'll put you in there also. Right. About 8 or 9 people told me to have a good weekend. So I guess I should. All right, live feed is on, record is on. The world's most boringest live stream. But it doesn't have commercials, so at least we got that going for it. will be at the district judge. Minutes. Just checking in. The attorneys are still talking. I'm going to give them about 5 more minutes. I don't really want to go through my whole lunch hour on this case. So at about 11:40, I'll bring them back. But I didn't forget you. They're still talking. So. All right, I'm going to bring them back. I expect this will probably go into lunch. I guess it's my own fault for setting it at 11:15. I'm not sure where you were in your discussions, but I brought you back because mostly I didn't want to end up doing all this during the lunch hour to see where we are. You had about 20 minutes there to discuss things. What's the current status?
Your Honor, I think that I'm going to propose a resolution today by email. I think in the meantime, she's requested that she may have some discovery stuff that we could plan. It would be my proposal that we set a trial date or hearing date, however it's referenced in the court. I'm not sure how the court feels about it, but like 6 weeks out, and I think we could resolve it. I do know escrow from your word that was not paid. I'm not requesting a default today for that. I just request that she get that caught up.
Ms. Long, that's only $99. I asked you to pay July's rent, and August rent is due tomorrow. And I'm disappointed that you didn't pay the escrow funds. I do have a date open, August 19th, although that's why I can't use that date. All right, Ms. Bauer, what's your response to Mr. Gromer's request?
That conforms to the discussion that we had. I propose that we set some witness and exhibit list exchange timelines to mitigate the
last termination case we started has taken like 5 days, and it's extended over multiple days, and I don't have large blocks of time, but if we're going to go 6 weeks, I guess I can block out an afternoon in September.
The good news is, Judge, that the allegations in this case are far less extensive, and I don't think it will take nearly the time that other case is taking.
All right.
At my age, I don't have the stamina to do a 5-day trial, so I can guarantee you, mine will not take longer than an hour.
Almost every case I ever tried, I tried 108, 107 here and one another felony trials as a prosecutor.
Judge, I have a
I don't know
question.
Yes?
So I do have.
You interrupted my fascinating story, but.
Sorry, it's something I need to know because I do have 3 money orders to pay this stuff. Where do I go exactly to pay it?
You pay it to the court.
So in Centerville?
Yes.
Okay.
Can we hear the end of the story?
Yeah, I was thinking that
Well,
too.
okay. I never tried one that took more than 5 days, except I tried a murder case once in Adrian that took 12 days. But anything, even the worst case I ever did, I was able to do in 5 days. But sometimes landlord-tenant cases take longer than that. Let's see here. How about Fair Week, September 23rd at 1 o'clock?
Works for me, Your Honor.
Is that?
My computer's still getting that far. Well, it helps if I click the right buttons too. Yes, Judge, that works for me.
All right, witness and exhibit list. We'll make them due by September 2nd. I'll block out the entire afternoon. That will be live. So, Ms. Long, I'm assuming you've got that money set aside, so you can pay July and August, and then you'll also have to pay September before we get into September. But we'll continue this matter for bench trial Wednesday, September 23rd at 1 o'clock. And witness and exhibit list will be due by September 2nd. All right, anything else we should place on the record?
Not for me, Your Honor. Thank you.
The defense is.
Ms. Cousineau, is there an issue with Mr. Cofield still being there?
This past week, we haven't seen him that I'm aware of.
All right. Well, we'll see where we go. In the meantime, you guys could continue to discuss either settlement or at least narrowing the issues. And we've got it set for a bench trial for 4 hours on September 23rd at 1 o'clock.
Thank you, Judge.
Yep. Thank you, Judge. Thank you, Jim.
Thank you. How we go to Mike? Bye-bye.
Ms. Long, I'll follow up with you right after we get off.
All right. Have a good weekend, guys.